Have you started or are you looking to start your own business and you have some special or confidential information that you'd like to protect? Well, if you're wondering about how to go in protecting this information, keep on watching. My name is Pamela Metani and I'm the principal lawyer and founder here at Graphene Business Law, a law firm that serves clients virtually throughout Ontario and can help you launch your business, grow your business, and conclude your business. If you're new to this channel, give this video a thumbs up and click on the red subscribe button down below. We regularly post content here that is most relevant to business owners and entrepreneurs. Now, it's been quite a while, I would say at least 10 or so years, that confidentiality, proprietary information, non-disclosures, data, these topics and the legalities behind them, but the words themselves, the terms themselves, have entered mainstream conversations, if you will. I think you'd be hard-pressed now if you're an employee to enter a workplace not having to sign some sort of confidentiality agreement. You'd be hard-pressed to deal with another business partner and not have to sign confidentiality agreements, depending, of course, on the sophistication of the business partner you're working with. But as far as business practice goes, these agreements should always be in place to best protect both parties, really, but if you're the one that's disclosing the information, to especially protect your interest. Okay, and we've posted on this channel about some of these agreements, if you will. For example, we have content here on non-disclosure agreements and confidential agreements. Confidentiality agreements are just another legal agreement that binds parties sharing that special sauce kind of information to the terms of how they're going to be sharing it, right? So in other words, if what you're sharing is special, how can it be special if I can do anything with this new knowledge or with this new information? There's obviously guidelines and rules and restrictions we're going to be keeping or wanting to keep in place in dealing with each other with such, again, special, confidential, unique information, okay? So I wanted to spend some time in this video, of course, dedicated to business owners and entrepreneurs, and talk about some of the sections that we might see in confidentiality agreements. Again, this is not legal advice that I'm putting out on this channel. It is educational content so that when you do get yourself in front of a lawyer, you're able to better use that time together. You're able to hit the ground running saying, well, I've already seen this video Graphene put out, you know, super helpful with all of these sections, and can you tell me how we'll be applying those sections to my interest when you get in front of that lawyer? And goes without saying, at Graphene Business Law, we can help you with confidentiality agreements as well. Now, I'm looking at agreement here, an example. Of course, you know, no identifying information or anything like that, but you're going to see me looking down because I'm looking at a concrete confidentiality agreement to go over some of the main sections with you. And I'll say in particular, I'm looking at an example that we've used a lot in the startup sense with startups. You can, of course, even if you're an established business, use confidentiality agreements. As lawyers, we would protect you and help you in tweaking the legalities in a way that they're most appropriate and relevant to you. But big picture, as far as some of the most important sections in a confidentiality agreement go, we're going to be having what's called the definitions, those opening sections about dates and parties involved and things like that. That goes without saying. We're also going to be identifying or outlining what the provision of confidential information looks like in that real life scenario, in that real life sense. So who is providing what information and what are we agreeing to as regards this information? So obviously we're going to be agreeing to keep this information confidential, to not use it in any way except for as is outlined in the agreement at hand, things like that, right? We want to have a narrow or as narrow scope as possible while still being commercially viable for you and for the purposes of growing your business. We want to have as narrow scope as possible to capture as much content and prevent that confidential information from leaking out through loopholes in the contract, if you will. So there's the provision of confidential information section. Then there's a section in confidentiality agreements we often see that's literally quite the opposite of what is being provided, and that is what is being excluded. Okay, so excluded information. What information is not captured by the terms of this confidentiality agreement? One style of language we often see here is that this information might be information that was already publicly available. So if something about your company was in the news for like a year before you entered into this agreement, well, that's not confidential, because anybody, we're in Ontario, so anybody reading the Toronto Star or the Globe is going to be privy or can be privy to that information. There's nothing confidential about it. If you happen to share, another example is if you happen to share information that you don't expect to be preserved as confidential, that could be a trickier clause, because you might think that everything you're saying is captured by the confidentiality agreement. But again, that's where you need strong legal protections for us to identify for you exactly what is and is not shared. But there are things, that can be excluded from confidentiality agreements as well, including, by the way, items that you're specifically agreeing to exclude with the other party for whatever reason. Then we're going to have a section, if you will, right? So we've talked about now things we are capturing, aka things that for sure we're going to keep confidential, and this is how we're doing it. And we've talked about on the other side things that we're not really capturing in this agreement. Well, as you can see, there's some sort of gray zone created here, because there might be circumstances in which we do need to share some information, right? If you're starting that initial conversation with a business partner, whether you are a fresh startup or a more established business, it can be a very small business, but a more established business, that's two parties coming to the table. And while it's possible, it's not necessarily the case that these two parties alone are going to be able to run all the way with the ideas and what comes out of this agreement and this business relationship. You will often need to include others in making the dream that these two parties are working on come true. Who do these others mean? These others could mean employees. You might need to hire new people on board, and you're going to need to share with them what it is that the special sauce is, insofar as it's necessary for them to run the business. Okay, there might be suppliers that you are purchasing from. There might be people that your special sauce is being sold to. Okay, and sometimes it's necessary to speak to some of that specialness or uniqueness of whatever made this relationship so proprietary, right? Some of what is captured by the confidentiality agreement might need to be divulged to other parties. Again, in this case, it's not, in case that sounds scary and like, this wild west, what's the point of you signing a confidentiality agreement with one party if, as a result of this relationship, other persons need to be involved and now they can tell anybody anything they want to? Well, again, as you can imagine, and certainly here at Graphene Business Law, we would help you govern those offshoot relationships as well, right? Whether it's with NDAs, non-disclosure agreements, or confidentiality agreements, or data share agreements, whatever the case is, we're going to find ways to protect each and every single one of the relationships coming out of this primary confidentiality agreement and the relationship that's formed there, okay? There's going to be representations made. So representations and warranties, while they both technically, legally mean different things, those terms, big picture, we're talking about, I'm telling you something is true. I can back something up. So the party that's disclosing the information is going to have reps and warranties on it in terms of the accuracy, for example, of the confidential information they're sharing, the completeness of it, the capability of them to actually control this information. Again, in non-legal terms, their ability to back up, walk the talk, or walk the walk, if you want to parse it, walk the walk of the talk of that special information that they're sharing with you, okay? There's other sections, of course, there's other sections, they kind of hover again, big picture around who owns the information and what we can do with it. And we're going to see always at the end of these agreements termination clauses. So under what circumstances does this relationship cease to be? It can be, for example, at a contractually agreed upon date. So if you're doing a 3-month sharing of information project with somebody, you know, at the end of that 3 months, if it's a 3-month contract, it's terminated. There can also be extenuating circumstances that might require you to terminate these agreements early, and of course we would put protective language in place there. And you should ask when you get in front of a lawyer, under what circumstances can you terminate this agreement, okay, and what the consequences of that are. For example, we're not going to, or you can imagine how it might not be that just because the agreement is terminated, now you can say whatever you want to anybody about what you came to learn as a result of this confidentiality agreement. Because then people are going to use that as a loophole to sign an agreement, learn everything, terminate it the day after, and now we can just, you know, fire through the market with this new information, right? There's steps in place to doing things right in the eyes of the law, okay, and to protecting yourself. And I'll talk about one last clause. It's called non-solicitation. That's something we see here. To solicit, you know, again, in non-legal terms, it is kind of to attract the attention of perhaps somebody you might not be supposed to, you know, not necessarily make good use, be a little on the mischievous, on the nefarious side with the information you've come to learn. So you can't be, you know, hiring or soliciting like your competitors' employees, for example, as a result of the information you came to learn from working with them. You can't be soliciting their business partners because now you know their special sauce. You can't be attracting the attention of people you're not supposed to as a result of content that you came to know only as a result of this agreement, right? You can't be asking or trying to obtain something from this agreement that you would not have been able to had you not signed. Not in the business growth sense, again, in the nefarious sense. Don't go stealing other people's employees and ideas and business partners, okay? I'll leave the video there. I mentioned at the beginning that confidentiality agreements are one of the type of, I call them special sauce agreements or idea agreements, that protect whatever's proprietary about your business, and they protect the conversations you're having with others about that unique or proprietary sauce to your business, okay? There's other types of these agreements that might be better suited for you. For example, data share agreement might be one of them. We can, of course, talk these things out if that's the setting you're in with your business, that you're finding, you know, it's a good time to grow, and growing through sharing your ideas with other people, and of course making sure that you're as protected as you can be in taking those steps. So here at Graphene Business Law, you can reach us at any time at our welcome email address is info@graphenebusinesslaw.ca, and our website, of course, is graphenebusinesslaw.ca. Thank you for watching.